In August of 1849, a man of business vanished from his usual lodgings in London, and no one could account for where he had gone. It was a week before a police officer noticed that one flagstone in a Bermondsey kitchen lay damp and out of place, and lifted it. The woman later accused of causing that disappearance was Marie Manning, born Marie de Roux in Lausanne, Switzerland, in or about the year 1821. She was approximately 28 years of age at the time of the killing, and she was the wife of Frederick George Manning, in whose house at number 3, Miniver Place, Bermondsey, the crime took place. Bermondsey, in 1849, was a densely built district on the south bank of the Thames, given over to tanning, leatherworking, and other trades that left the air heavy with the smell of hides and lime. Its streets were narrow and closely terraced, and its housing was crowded, much of it occupied by tradesmen, dockworkers, and clerks of modest means. Miniver Place was a street of this ordinary character, a row of small terraced dwellings with little to distinguish one from another. The house numbered 3 was one such dwelling, a modest 2-storey home with a kitchen at ground level. The floor of that kitchen was laid with flagstones, and it was beneath one of those flagstones that the case would come to rest. Nothing about the street or the house marked it as the scene of a planned killing. That ordinariness would later be set against the calculation the record showed had gone into what happened inside it. Marie de Roux's early life, prior to her arrival in England, is not established in detail in the surviving record. What is documented is that she travelled to Britain and entered domestic service, and that she rose within that service to the position of lady's maid, a post of some trust and standing within a household, well above that of an ordinary servant. She is recorded as having served in this capacity in the household of Lady Pulk, of Holden House in Devon, and afterward in the household of Lady Blantyre at Stafford House in London. These were not modest situations. Stafford House in particular stood among the grandest private residences in London, and a position within it placed Marie de Roux, an immigrant domestic servant, within the daily orbit of the English aristocracy. It was a considerable rise for a woman of her origins, and it is the only established fact of her working life before her marriage. The record does not establish the circumstances under which she left either household, nor does it establish details of her family, her parents, or her education in Switzerland. It was during this period, while in domestic service, that she became acquainted with Patrick O'Connor, an Irishman employed as a gauger, an officer of the excise at the London docks. The nature and length of their acquaintance before her marriage is not fully established, though it is documented that the friendship between them was of long standing, and that it continued without interruption after she married. In May of 1847, Marie de Roux married Frederick George Manning. Frederick had, before the marriage, been employed on the railways, and he had been discharged from that employment on suspicion of involvement in a series of robberies. This is a matter of record, not supposition, and it establishes that Frederick Manning brought into the marriage a documented history of suspected dishonesty. No prior deaths are recorded in connection with either party before the death of Patrick O'Connor in August of 1849. This is not a case with a history of prior suspicious deaths attached to it. It is a single event, and the record should be read as such. If you value cases preserved through court records, testimony, and verified documents, follow or subscribe wherever you're listening. The record resumes in Bermondsey in 1849. Patrick O'Connor was at the time of his death a man of considerable private means, though his official position was a modest one. He held the post of gauger at the London docks, an excise officer responsible for measuring and assessing goods subject to duty. Alongside this employment, he carried on a private business as a moneylender, charging rates of interest that contemporary accounts describe as extraordinarily high. Through this business, he had accumulated a personal fortune well beyond what his official salary could have provided. Among his holdings were shares in the Huntingdon, Wisbech and St Ives Railway, a number of which were later found in the possession of Marie Manning after her arrest. O'Connor lodged at Greenwood Street off the Mile End Road in East London. His exact age at the time of his death is not established in the surviving record, and no figure is given here in its place. What is established is that he was a man in later middle age, financially independent, and known to the Mannings as a friend of long standing. His friendship with Marie predated her marriage, and it is documented that the two remained close after she became Frederick Manning's wife. The precise character of that continuing friendship, whether it remained a romantic attachment or had settled into something else, is not resolved in the surviving sources, though it was widely assumed at the time, and reported in the press of the day, to have continued as an affair. The record does not permit a firmer statement than this, and none is made here. By the summer of 1849, the Mannings were established at number 3, Miniver Place, and their financial position was not a settled one. Frederick Manning's employment history had already shown a pattern of instability, and the couple's documented motive for what followed was the acquisition of Patrick O'Connor's money and his railway shares. There is no burial club policy and no life insurance arrangement recorded in connection with this case. The motive established by the evidence was direct and immediate, the theft of property and cash that O'Connor already held, not the collection of a policy taken out in advance. The single strongest piece of evidence bearing on the couple's intentions was physical rather than financial. Beneath the flagstones of the kitchen at number 3, Miniver Place, a grave had been dug in advance of the killing. This is not a matter of inference. The excavation of that grave necessarily preceded the 9th of August, 1849, the date on which Patrick O'Connor came to his death, and it establishes that the killing which followed was planned rather than the outcome of a quarrel that escalated without warning. On the 9th of August, Patrick O'Connor was invited to dine with the Mannings at their home. Given the grave already prepared beneath the kitchen floor, the invitation itself formed part of a plan already in motion before he arrived. On the evening of the 9th of August, 1849, Patrick O'Connor came to number 3, Miniver Place, at the Mannings' invitation to take dinner with them, as he had done before. In the course of that visit, he was shot at close range in the back of the head. Multiple secondary accounts of the case report that the gunshot wound did not kill him immediately, and that Frederick Manning then struck him further with a crowbar to complete the killing. This detail is consistently repeated across accounts written after the trial, though it is not confirmed here directly against the wording of the surviving trial transcript, and it is set down in that spirit as a widely reported detail rather than a verified quotation from the proceedings. Following the killing, O'Connor's body was placed in the grave already dug beneath the kitchen flagstones, and quicklime was added to the burial. There was no period in which O'Connor's death was recorded as a natural one. No physician attended a deathbed, and no certificate was issued describing a death by illness. The case did not proceed, as many on this record do, from a certified natural death later called into question. It proceeded instead from a disappearance, followed some days later by discovery. That disappearance was noticed within a matter of days. Patrick O'Connor did not return to his lodgings at Greenwood Street, and he did not appear at his customary places and habits. Acquaintances who were used to seeing him regularly began to ask after him, and word of his absence reached others in his circle. Suspicion, in this case, did not develop through the slow progress of an illness observed by a nurse or a physician, as it does in a poisoning case. It developed instead through the ordinary channels by which a missing man's disappearance comes to the attention of others, and eventually of the police, who began to trace his last known movements. Those movements led to the house, at number 3, Miniver Place. In the interval between the killing and the discovery of the body, Marie Manning went to O'Connor's lodgings at Greenwood Street on the day of the killing itself, and removed from those rooms his railway share certificates and a sum of money. She returned to the same lodgings the following day and completed the removal of his effects. This is documented plainly in the record as the stripping of the victim's rooms in the immediate aftermath of his death, and it stands as a clear indication that the financial motive behind the killing had been settled upon before the act itself, not devised afterward in panic. Neither Marie nor Frederick Manning fled London together, and this is a significant feature of what followed. Each of them made independent arrangements to leave, and each attempted, separately, to take the greater part of the proceeds of the crime, leaving the other exposed to discovery. This was not a partnership that held together once the act was done. The record documents are falling out between them over the disposal of the stolen property, each seeking personal advantage over the other, and this division would resurface in a different form at their trial some months later. On the 17th of August, 1849, a week after the killing, a police officer engaged in the inquiry into O'Connor's disappearance examined the house at number 3, Miniver Place. He observed that one corner flagstone of the kitchen floor was damp, and that the earth beneath and around it was disturbed and softer than the ground surrounding it, unlike the rest of the floor. On lifting the flagstone, he found the body of Patrick O'Connor buried beneath it, with quicklime present in the grave. It was this single observation, a stone that did not match its surroundings, that converted a missing person inquiry into a murder investigation. The examining officers and any police surgeon who subsequently examined the remains are not named in the surviving record, and no names are supplied here in their place. What is established is the sequence itself. A week of silence, an officer's attention to a small physical anomaly in an otherwise unremarkable kitchen floor, and the discovery that followed directly from it. By the time the body was found, both Mannings had already left London. A list of Patrick O'Connor's stolen property was compiled and circulated to assist in tracing the couple, including a description of the railway share certificates known to have been in his possession before his death. The Huntingdon, Wisbech and St Ives Railway, in whose shares he had invested, furnished the particulars necessary to identify the certificates by number, and it was this paper trail, more than any other single measure, that guided the police toward the fugitives. Marie Manning was traced to Edinburgh. She had travelled north under her own name, and she was apprehended there in the course of attempting to exchange or dispose of some of the stolen property. At the time of her arrest, 10 share certificates of the Huntingdon, Wisbech and St Ives Railway were found in her possession, matching the description already circulated in connection with O'Connor's estate. Frederick Manning was traced separately to the island of Jersey and was arrested there. The two had not travelled together, and neither had waited for the other, a pattern consistent with the falling out already noted in the disposal of the stolen goods. The named officers responsible for these arrests are not established in the surviving record, and the exact words spoken by either Manning at the moment of arrest are not recorded here. No statement is invented to fill that gap. What is established is the outcome: 2 separate arrests, in 2 separate places, each following the recovery of property that tied its possessor directly to the dead man's estate. The Metropolitan Police, whose jurisdiction covered Bermondsey and the surrounding districts of London, carried the investigation forward from the discovery of the body to the point of arrest. The interval between the 17th of August, when the flagstone was lifted, and the eventual apprehension of both suspects was one in which the case drew increasing attention in the London press, aided by the circulation of the list of stolen property. It was this publicity, as much as any single piece of police work, that placed the description of the railway shares before members of the public in a position to recognise them, and it was this recognition that led to Marie Manning's arrest in Edinburgh. The stolen certificates functioned, in effect, as a signature left behind by the crime, traceable through the ordinary machinery of commerce, even after the persons who had taken them had left London far behind. Following the arrests, an inquest into the death of Patrick O'Connor would have been convened as a matter of standard procedure, as was required at this date, following the discovery of a body under circumstances suggesting unlawful killing. the presiding coroner the specific venue at which the inquest was held, and the witnesses called before it are not established in the surviving record. The inquest's recorded verdict, if one survives, is likewise not established here. What is documented with certainty is that the case proceeded from the discovery of the body through committal proceedings to trial at the Old Bailey, and it is at that later stage that the fullest surviving record of the evidence against the Mannings is to be found. No detail of the inquest is supplied here beyond what can be stated plainly, that it took place as procedure required, and that it did not alter the course the case would take toward trial. The trial of Marie and Frederick Manning opened at the Old Bailey, the Central Criminal Court of London, in late October of 1849. Secondary accounts of the case place the hearing on the 25th and 26th of October, while the surviving Old Bailey proceedings record the case under a session dated the 29th of October. This discrepancy is noted here, rather than resolved by invention, and the trial is described simply as having taken place in late October of 1849. Both defendants were arraigned on a charge of willful murder, and both entered pleas of not guilty. Each in the course of the proceedings, in substance, sought to place the greater weight of blame upon the other, a division that had begun with the separate flights to Edinburgh and Jersey, and that now continued formally before the court. Before the trial proper began, an argument was raised on Marie Manning's behalf concerning the composition of the jury. As a Swiss national tried before an English court, it was argued that fairness to her position required a jury constituted, in whole or in part, of persons of foreign extraction, sympathetic to the position of a defendant tried in a legal system and a language not her own by birth. English law at this period recognised, in certain circumstances, a provision for a mixed jury in cases involving foreign defendants, drawing jurors partly from the general population and partly from among resident foreign nationals. Whether this specific provision was invoked by name in Marie Manning's case, and whether the court granted, refused, or partially accommodated the argument, is not established with certainty in the surviving record. What is documented is that the argument was made, and that it reflects a broader concern, voiced on Marie Manning's behalf, that her position as a foreign-born defendant before an English jury placed her at a disadvantage that an ordinary jury selection would not address. The court's precise ruling on the point is not asserted here, in the absence of confirmation from the trial transcript itself. The prosecution and the counsel appearing for each defendant are not named in the surviving record. They are referred to here by function rather than by name. The prosecution, counsel for Frederick Manning, and counsel for Marie Manning. The presiding judge is likewise not named here. At an Old Bailey session in October of 1849, the bench would ordinarily have been occupied by one of a small number of senior judicial figures attached to the sessions, but no specific name is confirmed in the surviving record, and none is supplied in its place. Among the witnesses called by the prosecution was Francis Stevens, who had served as Patrick O'Connor's stockbroker. Stevens gave evidence identifying the railway share certificates recovered from Marie Manning at the time of her arrest as certificates that had belonged to O'Connor before his death. He testified to this identification by reference to the serial numbers recorded upon the certificates themselves, and by reference to initials that he had himself placed upon them in the ordinary course of his business dealings with O'Connor. This testimony supplied the court with a direct and traceable link between the property found on Marie Manning in Edinburgh and the estate of the murdered man, closing the distance between the theft and the killing with a specificity that few other pieces of evidence in the case could match. A stockbroker's ledger and a set of numbered certificates did not depend on memory or impression. They were documents, and they spoke for themselves once placed before the jury. James Coleman, who resided at number 1, Miniver Place, and who held the position of landlord in that neighbouring property, also gave evidence at the trial. The substance of his testimony beyond his position as a near neighbour of the Mannings is not further established in the surviving record, though his presence among the witnesses called indicates that the immediate vicinity of number 3, Miniver Place, and the ordinary comings and goings observed by those who lived close by formed part of the case the prosecution presented to the jury. Neither Marie nor Frederick Manning was permitted to give sworn evidence in their own defence, this being decades before such a right was extended to defendants in English criminal trials. The only avenue open to either of them was an unsworn statement made from the dock, a customary practice of the period by which a defendant might address the court directly without being subject to cross-examination. Frederick Manning made use of this opportunity, and in the course of his statement is recorded as having said that he had never liked Patrick O'Connor very much. The remark survives as one of the few verbatim fragments of either defendant's own words to come down from the trial, and it is delivered here without further comment, since none is required. Each defence in substance sought to place the weight of the killing on the other party. Counsel appearing on Marie Manning's behalf emphasised Frederick Manning's own history of suspected dishonesty and the physical nature of the act itself, seeking to distance her from direct responsibility for the fatal violence. Counsel appearing on Frederick Manning's behalf framed his position, according to secondary accounts of the trial, in terms of jealousy, pointing toward the continuing friendship between his wife and the murdered man as a motive bearing more heavily upon her than upon him. This mutual attribution of blame between co-defendants formed a central feature of the trial's adversarial character, with each defence working, in effect, against the other as much as against the Crown. The medical evidence placed before the court concerned the physical cause of death, established through examination of the remains recovered from beneath the kitchen flagstones. A medical witness is understood to have testified to the nature of the injuries found upon the body, consistent with a gunshot wound to the back of the head, though the name of that witness is not established in the surviving record. The additional injury, attributed in secondary accounts to a blow or blows from a crowbar delivered after the gunshot itself, is not confirmed here as a matter directly quoted from the surviving transcript, and it is treated as a detail reported consistently in accounts written after the trial, rather than as verified trial testimony. The case for the Crown, taken as a whole, rested upon three converging lines of evidence: the physical discovery of the body in a grave demonstrably prepared before the killing took place, the recovery of stolen property traceable by serial number to the dead man's own broker, and the flight of both defendants from London by separate routes immediately following the disappearance of Patrick O'Connor. Against this, the defence offered on behalf of each Manning consisted chiefly in directing the jury's attention toward the other defendant, a strategy that, whatever its merits, as an attempt to divide responsibility, left the underlying facts of the killing and the theft largely undisputed. The presiding judge's charge to the jury summarised the evidence presented over the course of the trial, though the specific content of that summing up is not preserved in the surviving record. The jury retired to consider its verdict, and its deliberation lasted approximately 45 minutes. On its return, the jury delivered a verdict of guilty against both defendants on the charge of willful murder. Upon the verdict being announced, Marie Manning addressed the court and is recorded as having denounced the English as a perfidious race, a remark that survives as one of the most frequently quoted reactions recorded from any defendant in a 19th century English courtroom. It stands in the record as her own words at the moment her conviction was confirmed, and no further interpretation is placed upon it here. The trial concluded with both Marie and Frederick Manning convicted of the willful murder of Patrick O'Connor, on evidence that included physical discovery of the body, documentary identification of stolen property, and the flight of both defendants from the scene of the crime. The jury's deliberation was brief, its verdict unanimous against both defendants, and the case moved, without further contest, as to guilt towards sentencing. Both Marie and Frederick Manning were sentenced to death upon their conviction. The words spoken by the presiding judge in passing that sentence are not preserved in the surviving record, and none are supplied in their place. What is documented is the sentence itself, and the fact that it proceeded to carry out its full and final term without interruption. In many cases of this period, a conviction of this gravity was followed by a petition to the Home Secretary, seeking a reprieve on grounds of doubt, of provocation, or of clemency owed to a particular circumstance of the condemned. No such petition and no such campaign for clemency is recorded in connection with either Marie or Frederick Manning. The record here should be read plainly. There was no reprieve sought, and none was granted, and the sentence of the court proceeded directly toward its execution. The case attracted an extraordinary degree of public and press attention in the weeks between the conviction and the execution. The Times and other London papers carried extensive coverage of the trial and its outcome, and the volume of printed material produced in connection with the case exceeded, by a considerable margin, what any ordinary criminal trial of the period would generate. Broadsides, the cheaply printed sheets sold on the streets of London, recounting the details of notable crimes, were produced and sold in connection with the Manning case in a quantity estimated at approximately 2.5 million copies within the year of the trial. This figure, drawn from period estimates, exceeded by more than 30 times the annual circulation of the Illustrated London News for the previous year, a comparison that gives some sense of the scale of public appetite the case had generated. A husband and a wife, tried together, convicted together, and sentenced together, for a killing carried out in an ordinary house, on an ordinary street, had become, in the space of a few months, one of the most widely discussed criminal cases in the country. Marie and Frederick Manning were executed together on the roof of Horsemonger Lane Gaol in Southwark on the 13th of November, 1849. The public executioner on that occasion was William Calcraft, who held the office of hangman for the City of London and the county of Middlesex for much of the mid-19th century. The execution was conducted in public, as was standard practice for capital sentences at this date, and it drew an assembly of spectators estimated in contemporary accounts to number in the tens of thousands, though no single figure can be confirmed with precision from the surviving record, and none is stated here beyond the description of an enormous crowd. This was the first occasion since the year 1700 that a husband and wife had been executed together in England, a fact noted at the time and repeated since as one of the case's defining features. In the period immediately preceding the execution, Marie and Frederick Manning, who had spent the months since their arrest blaming one another, first at the point of their separate flights from London, and again in the adversarial character of their defences at trial, were reconciled. This reconciliation is documented as having taken place shortly before the hanging, and it stands as the final recorded turn in a relationship that had, by the time of the killing itself, already shown signs of mutual calculation and mutual suspicion between husband and wife. Both were buried within the grounds of Horsemonger Lane Gaol, following the execution, in keeping with the standard practice of the period for those put to death under sentence of the criminal law, a practice that would later be given formal statutory footing, but which was already the ordinary custom at London jails such as this one in 1849. Among those who witnessed the execution in person was the novelist Charles Dickens, who attended and who wrote, on the same day, a letter to the Times condemning what he described as the wickedness and levity of the immense crowd assembled to watch two human beings put to death. Dickens's letter is counted among the most frequently cited pieces of writing produced in connection with the Victorian campaign against public execution, and the Manning case, through his testimony, became one of the most widely referenced episodes in that campaign's history. It is important to state plainly what this letter did and did not accomplish. Public executions in England did not end as a direct result of the Manning case, nor as a direct result of Dickens' letter. They continued for a further 19 years, until the passage of the Capital Punishment Amendment Act of 1868 moved the carrying out of death sentences behind prison walls, away from public view. What can be said of the Manning execution with accuracy is that it sharpened and publicised an argument already gathering force against the practice of public hanging, and that Dickens' account of the crowd he witnessed at Horsemonger Lane became one of the most quoted single pieces of testimony in that argument's favour. The case did not change the law, it changed, in some measure, how the law's opponents were able to make their case. Also present among the spectators that day was the American novelist Herman Melville, then travelling in England, who paid £50 for a place on a rooftop overlooking the scene, and who recorded his impressions of the execution in his own diary. Melville's account, like Dickens's letter, survives as a documented eyewitness record of the crowd and the scene at Horsemonger Lane on the morning of the 13th of November 1849, offered from the perspective of a visitor rather than a resident critic of English penal practice. The case is also understood to have left a trace in English fiction beyond Dickens's direct journalistic response to the execution itself. Critics and biographers have traced a connection between Mary Manning and the character of Mademoiselle Hortense, the vindictive French lady's maid who appears in Dickens' novel Bleak House, published some 3 years after the Manning trial. This connection is repeated across a number of independent reference sources and is treated here as a documented critical and biographical tradition, though it should be understood as a claim traced by later critics and biographers, rather than as an intention Dickens himself is recorded as having stated. Wilkie Collins, another novelist of the period, is understood to allude to the Mannings in his novel The Woman in White, published in 1860, though this too is treated as an allusion identified by later readers of the text rather than as a direct portrait acknowledged by the author. One further piece of tradition attached to the case concerns the clothing Marie Manning is said to have worn to the scaffold. It has long been held, and is repeated in numerous popular accounts of the case, that she wore a garment of black satin to her execution, and that this association was sufficiently strong in the public mind to depress the fashion for black satin among English women for a generation afterward. This claim forms the title of a well-known scholarly study of the case published in 1981. Examination of surviving fashion catalogues from the years following the execution does not support the claim of any lasting effect on the popularity of black satin as a fabric, and the tradition is presented here as exactly that, a widely repeated legend rather than an established fact, though some accounts note a brief, short-term dip in the fabric's popularity in the immediate aftermath of the case. The tradition persists in popular retellings of the case, but the surviving documentary record of the period's fashion trade does not bear it out. Physical relics of the case survive in more than one location. Marie Manning's death mask, cast following her execution, as was a common practice of the period for notable criminal cases, is held at Dumfries Museum in Scotland. The grave markers belonging to Marie and Frederick Manning, preserved at the time Horsemonger Lane Jail was demolished in 1881, are now held by the Southwark Heritage Centre and stand as one of the few physical objects connecting the present day directly to the burial ground in which the couple were interred following their execution. The Manning case occupies a particular place in the social history of mid-19th century England, distinct from the more familiar shape of the poisoning cases that dominate the criminal record of this period. In 1849, a married woman in England possessed no independent legal personality with respect to property. Whatever she owned before marriage, and whatever came to her during it, passed under the legal control of her husband, a state of affairs that would not begin to change until the passage of the Married Women's Property Acts of 1870 and 1882, decades after the events at Miniver Place. This legal condition is not directly at issue in the facts of the Manning case, since no dispute over property held by Marie Manning in her own right forms part of the record, but it stands as relevant background to any account of the limited legal room a married woman of this period possessed to act independently of her husband, whatever the practical realities of a given marriage might have been. Marie Manning's own conduct in this case does not appear to have been constrained by that limited legal standing. She travelled alone to Edinburgh. She disposed of stolen property in her own name. She addressed the court in her own words at the moment of her conviction. Whatever the formal legal position of a married woman in 1849, the record of this case shows a defendant who acted throughout with considerable independence from her husband, even as the two were tried, convicted, and ultimately executed together. The press coverage of the trial made frequent reference to Marie Manning's foreign origin, and a number of contemporary accounts attributed to her a capacity for cold and calculated conduct that these accounts explicitly connected to her being Swiss and French by birth rather than English. This framing recurs across multiple newspaper accounts of the period and should be understood plainly as a reflection of the prejudices of the English press of 1849 toward a foreign-born defendant, not as a documented insight into Marie Manning's actual character or state of mind. The record establishes what she did. It does not establish, and this account does not assert, any connection between her conduct and her national origin beyond the fact that contemporaries chose, at the time, to draw one. The office of gauger held by Patrick O'Connor at the London docks formed part of the machinery of His Majesty's Customs and Excise, an institution responsible at this date for assessing and collecting duty on goods entering the port of London. A gauger's particular function was to measure and assess dutiable goods arriving by ship, calculating the duty owed to the Crown upon them. It was not, in itself, a position of great wealth or status, and O'Connor's considerable personal fortune derived not from this office, but from his private activity as a moneylender, conducted alongside his official duties. Money lending of the kind O'Connor practiced operated largely outside any formal regulation at this date, and a lender charging the rates attributed to him in contemporary accounts could expect to accumulate capital at a pace his salaried post alone could never have matched. It was this accumulated capital, converted in part into railway shares, that made him a man worth killing in the eyes of those who stood to gain from his death. Railway shares of the kind O'Connor held in the Huntingdon, Wisbech and St Ives Railway were in 1849 a form of property that could be transferred from one holder to another, but which remained identifiable by reference to a register maintained by the company itself and by the serial numbers printed upon the certificates. This feature of railway shares as an investment, their registration and their numbering is what made them in the end an unsuitable form of plunder for anyone hoping to dispose of them without detection. Cash once spent left no trace of its former owner. A numbered share certificate did not behave the same way. It carried its history with it, in the ledger of the broker who had handled it, and in the records of the company that had issued it. When Francis Stevens identified the certificates recovered from Marie Manning by their numbers and by his own initials marked upon them, he was not offering an impression or a recollection. He was reading from a paper record that had existed, unaltered, since before Patrick O'Connor's death, and that record placed the stolen property in her hands beyond any real contest. The investigation that led to Marie Manning's arrest in Edinburgh depended upon this same feature of the stolen property. The Metropolitan Police, in circulating a description of the missing certificates to assist in tracing the couple, were relying on the fact that any attempt to sell or exchange the shares would require presenting them, at some point, to a broker or an institution capable of recognising their numbers. It was this attempt, made in Edinburgh, that placed Marie Manning within reach of arrest. She had travelled a considerable distance from London, out of the jurisdiction in which the crime had been committed, and into a different legal system altogether, that of Scotland. And yet the property she carried with her remained traceable regardless of where she carried it. Frederick Manning's flight to Jersey placed him similarly outside the ordinary jurisdiction of the English courts, the Channel Islands possessing their own distinct legal administration under the Crown, separate from that of England and Wales. That his arrest there was nonetheless achieved, and that he was returned to face trial at the Old Bailey alongside his wife, indicates that neither distance nor a separate jurisdiction was sufficient, in this case, to place either defendant permanently beyond the reach of the investigation once the stolen property had begun to surface. The legal argument raised on Marie Manning's behalf concerning the composition of the jury that would try her drew upon an old provision of English law permitting, in certain circumstances, a mixed jury for the trial of a foreign national, a jury de medietate lingue, constituted partly of English subjects and partly of persons of the defendant's own nationality or of foreign birth generally. This provision had its roots in medieval practice, developed originally to afford some measure of fairness to foreign merchants and other non-English persons tried before English courts in a legal system and a language not their own. By the middle of the 19th century, its use had become rare, and its application to a case such as Marie Manning's, an immigrant domestic servant turned defendant in a capital trial, would have represented an unusual invocation of an old and largely disused safeguard. Whether the court granted this request, refused it, or reached some accommodation short of a fully mixed jury is not established with certainty in the surviving record. What can be stated is that the argument itself reflects a genuine legal question raised at the time, that a Swiss-born woman tried for her life before 12 English jurors might reasonably be tried under different conditions than an English-born defendant would be, and that this argument was made in earnest on her behalf, whatever its outcome. Marie Manning's earlier career as a lady's maid placed her before her marriage within a social world that few domestic servants of the period were permitted to enter so closely. A lady's maid attended personally upon the mistress of a household, assisting with dress, with correspondence, and with the countless small tasks of a fashionable woman's daily life. And in doing so, she occupied a position of considerable intimacy and trust, distinct from the more distant relationship most servants maintained with their employers. In the households of Lady Polk and Lady Blantyre, Marie de Roux would have travelled in the same carriages, worn the cast-off garments, and overheard the private conversations of women whose wealth and standing were entirely beyond her own reach by birth. It is this proximity, without possession, that later commentators on the case have pointed to in attempting to understand the distance between the modest terraced house at No. 3, Miniver Place, and the grand London townhouse at Stafford House, in which she had once served. The record does not permit any firmer conclusion than this observation of proximity itself. It establishes where she worked and in what capacity. It does not establish what she felt about the disparity between that world and the one she came to occupy as a publican's wife in Bermondsey. The discovery of the body beneath the kitchen flagstones at No. 3 Miniver Place, and the manner of that discovery, deserves to be set down again in its full procedural weight, for it was this single observation, made by an officer walking the ordinary rounds of an investigation into a missing man, that turned the case from an open question into a certainty. A flagstone floor, laid across the ground level of a small terraced kitchen, does not, in the ordinary course of use, present any variation from one stone to the next. Damp will accumulate evenly, or not at all, across a floor of this kind, and the earth beneath such stones, undisturbed for years, settles into a uniform density that does not vary noticeably from one part of the floor to another. It was the deviation from this uniformity, one stone damp where its neighbours were dry, the earth beneath it soft where the surrounding ground had long since settled, that drew the officer's attention. Quicklime added to the grave beneath that stone would in time have accelerated the decomposition of the body it covered. But in the short interval between the burial and the discovery, its presence contributed to the disturbance in the soil that first caught the officer's eye. It is worth setting down plainly that no informant, no confession, and no accomplice's testimony broke this case open. It was broken open by the ordinary attentiveness of a man doing his job, examining a floor that did not look, in one small respect, quite as it should. The trade in broadsides that flourished around notable criminal trials in this period was a well-established branch of London's cheap print industry, distinct from the daily newspapers and pitched instead at street sale, hawked by criers through the crowds that gathered outside courts and prisons on the days of trial, sentencing, and execution. A broadside of this kind typically carried a brief and sensational account of the crime, sometimes an illustration, and very often a supposed final confession or last dying speech attributed to the condemned, whether or not any such statement had actually been made. The volume attributed to the Manning case, some 2.5 million sheets sold within the year of the trial, reflects the scale of a market that existed entirely apart from the machinery of the court itself, feeding on the same public appetite that drew the crowd to Horsemonger Lane on the morning of the execution. It was a trade conducted for profit by printers who had no stake in the accuracy of what they sold, and it stands as a measure of how thoroughly the Manning case had penetrated the ordinary commerce of the London street, quite apart from its standing before the law. The Old Bailey, at which Marie and Frederick Manning were tried, stood in the City of London beside Newgate Prison, the two institutions long associated in the ordinary administration of London's criminal justice. A trial such as that of the Mannings, already the subject of extensive newspaper coverage before it opened, would have drawn a courtroom filled beyond its ordinary capacity, with members of the press occupying places set aside for the reporting of proceedings that were expected, from the outset, to be read about across the country within days. William Calcraft, who carried out the execution at Horsemonger Lane, held the office of public executioner for the City of London and the County of Middlesex for a period extending across several decades of the 19th century. No detail of the mechanics of the execution itself is set down here, beyond the plain fact of it. What is documented is that Calcraft carried out the sentence upon both Marie and Frederick Manning on the same morning, on the same scaffold, before the same assembled crowd, an occasion made unusual by the fact of two persons, married to one another, executed side by side. Horsemonger Lane Gaol, the institution at which the execution took place, served at this date as the principal prison for the county of Surrey, standing on the south bank of the Thames in Southwark, a short distance from the district of Bermondsey in which the Mannings had lived and in which their crime had been committed. Executions at the jail were carried out upon its roof, in view of the street and the surrounding vantage points from which a public crowd could gather. It was from a rooftop overlooking the jail that Herman Melville purchased his place to view the proceedings, a common arrangement by which householders and landlords in the vicinity of a public execution could profit from the crowd such occasions drew, renting out windows and rooftops to spectators willing to pay for an unobstructed view. The jail itself was demolished in 1881, more than 3 decades after the Mannings were buried within its grounds, and it was at the time of that demolition that the couple's grave markers were recovered and preserved, eventually passing into the keeping of the Southwark Heritage Centre, where they remain. The falling out between Marie and Frederick Manning in the days immediately following the killing deserves to be understood plainly for what the record shows it to have been. Not a disagreement over whether the killing should have taken place, a question neither of them appears to have raised, but a contest over the disposal of what it had gained them. Each had access, in the immediate aftermath, to some portion of Patrick O'Connor's money and his railway shares. recovered partly from the house at Miniver Place, and partly, in Marie Manning's case, from the 2 visits she made to his lodgings at Greenwood Street. Rather than pooling this property and departing together, husband and wife each made separate arrangements to leave London, and each appears, from the pattern of their movements, to have sought to secure the largest possible share of the proceeds for themselves individually, leaving the other to manage with whatever remained. This is not a matter of speculation drawn from the general character of their marriage. It is documented in the divergent paths each of them took: Marie Manning north to Edinburgh, Frederick Manning south to Jersey, neither informing the other of a shared plan, each carrying away what they had been able to secure. A partnership formed to plan and carry out a killing, sustained through the digging of a grave and the hosting of a dinner at which that killing took place, did not survive the division of what the killing had been intended to produce. It is this collapse, as much as the killing itself, that the trial which followed would lay bare before the court, each defendant's counsel pointing across the dock at the other, husband and wife, bound together by the crime they had committed and divided by the proceeds they had fought over. The survival of this case in such documentary depth owes a great deal to the particular moment at which it occurred. By 1849, the Old Bailey proceedings were being published in a form intended for wide circulation, recording testimony in a manner considerably fuller than had been customary in earlier decades, and the London press had, by this date, developed the practice of sending reporters to sit through capital trials of public interest and transmit their proceedings, often within a day, to readers across the country. It is this convergence, a formal court record maintained for publication, and a press apparatus capable of relaying it swiftly to a national audience, that accounts for the density of surviving detail in the Manning case when set against many earlier trials, where only a coroner's brief note or a magistrate's committal record might survive. The numbered shares identified by a stockbroker reading from his own ledger, the flagstone noticed by a police officer walking his rounds, the unsworn remark delivered by a man from the dock. All of these details persist in the record. Not because the case was exceptional in its violence, but because the institutions responsible for recording it were, by 1849, capable of preserving an ordinary domestic killing in a documentary richness that earlier periods rarely afford. The case of Marie and Frederick Manning stands, in this respect, as much as a record of what mid-Victorian legal and journalistic institutions could capture, as it does a record of the killing itself, a paper trail nearly as complete as the one that led investigators to the stolen railway shares that first exposed it. The verdict was entered. The sentence was carried out at Horsemonger Lane Gaol on the 13th of November, 1849. The case passed into literature, and the question it left of a husband and a wife bound together in one killing and divided over its proceeds has outlasted everyone who asked it. What did he say?